Okay, I think with that we will kick off. So hello and thanks for joining us again today. We've got around about sort of 75, 80 people in the room at the moment, so we'll make a start with that, I think. So thanks for joining us. Today for today's Renters' Rights Bill Q&A. So unlike the previous ones that we've done, this we're not going to do a presentation. This is simply as it is, as it says, a Q&A, and we'll be going through a sequence of questions that we've had posted in advance. Some of those sort of came as a result of the last meeting that we did, and we couldn't mop up all those questions. So the idea is we're going to go through as many of the questions as we possibly can over around about a 30-minute window, hopefully. And then at the end of that, if there's any questions that get posted along the way, hopefully we'll be able to mop those up as well. So we're thinking around about 45 minutes for this today. So once again, normal thing. My name's Irving Hill. I head up Sulets. We run an educational charity here based in Leicester. We rent around about 2,300 rooms in a mixture of HMOs and PBSA. And we are linked directly to the two universities. Once again, we're lucky enough to be joined by David. So that's David Smith, who's a partner at JMW Solicitors, obviously now very well known in the sector. We're very lucky to have him, and he's a renowned industry expert. So I'm not going to talk much more. I'm just going to kick straight off with some of the questions that we've got and hand over to David. So if you just bear with me, and we'll try and share out the screen. And so away we go, as I say. There we are. So quick bit about who Sulets are, which I've just said, so I won't dwell on that, and we'll just go straight to the questions. So the first one is from John Kennedy, and he said, can you give an update on the second reading of what's in store for the committee stage, and what is in store for the committee stage, and also likely areas of change? I mean, obviously we've moved on from that. We did actually have the committee stage yesterday that occurred in Parliament. So over to you.
Yeah, so the committee stage started yesterday, as Irving is saying, and basically with a couple of exceptions, it's running all day, 2 days a week until I think the 28th of November, broadly speaking, the end of November. I suspect, although it's not timetabled yet, and you just never can tell, that this will be back into the floor of the House of Commons before Christmas for the report stage and third reading, which is mostly a bit of a wave through. To move on to the House of Lords with the intention of it hitting the House of Lords immediately after Christmas recess in January, but we'll have to wait and see on that. But the reality is the government's keeping it moving pretty fast. What came out of second reading? The second reading is just a proper introduction of the bill and a series of speeches. So things that I thought were interesting and what I picked out of it is the very clear set of positions from the government that they had pretty much made up their minds about most stuff already, and that cuts both ways. They were fairly dismissive of concerns from landlord groups, but they were equally quite dismissive of calls, for example, from rent control. So Jeremy Corbyn and a couple of other more left-wing Labour MPs broadly read out briefing notes that they'd got from the Renters' Rights Coalition, the Renters' Reform Coalition, looking for rent control, and they were brushed off as well. And the government pretty much said, well, we've thought about all of this. This is where we have landed, having taken into account all the stuff that was expressed under the previous reform bill, and we won't be changing much. Now, I note that today there have been some amendments laid in the committee stage, but they are all quite technical changes. So what do I think is up for change? Almost nothing in the bill apart from technical stuff around, things that they haven't intended to do quite right. So stuff they've forgotten little details that don't work quite right, or where they've done something that leads to an unintended consequence. But in terms of big ticket items, like, for example, some kind of exemption from students for all students beyond the PBSA, then no. Or some kind of minimum time period before tenants can give notice, then no. So it kind of depends what people mean by likely areas of change. Nothing that's likely to interest you is the short answer to that question. They're things that will interest me as a technical person, but not really of much interest to someone on day-to-day operation.
So people hoping for some sort of monumental change, or anything coming out of the committee stage, because I mean, I watched the because I'm a bit sad like that, really. I watched Parliament TV yesterday when it was on, and there was a sequence of people, including people from specifically from the student arena, like Unipol, that were on there, suggesting various, quite sensible changes, I thought, but you're not feeling that there's going to be much traction for any of these, then? I mean, obviously, we can only
the
surmise.
evidence stage finished yesterday, and as you know, the government was, they listened politely to everyone who gave evidence, but without betraying massive enthusiasm for what most of them were saying. And the reality is that the government kept a close eye on what happened with the Renters Reform Bill, and they fed in most of that stuff into their effective second draft. The Renters' Rights Bill is, in a sense, draft 2 of the Renters Reform Bill, because broadly the same with changes. So I don't think there'll be a lot of change. I mean, I'm always open to being wrong about these things. The reality is that you can never entirely predict what the government will do and what will happen in the passing of the bill, but I'd be very surprised if there's any significant earth-shattering alteration that makes people go, yay, wow, they've done X.
Yeah, they've listened to what we wanted. Yeah, okay. Right, rolling on. So we've got quite so is there any chance that the Renters Reform Bill will exclude student HMOs? I mean, I suppose it depends. Does he mean, I don't know what this is Daniel Scott's question. I suppose it depends whether he means the 1 and 2 bedrooms, because they haven't been exempted, have they?
No, it's HMOs only. And I mean, people will push for that. And it's possible the government will shift on that, but I'm not convinced that they will. Obviously, there's an exemption for PBSA, but that's going to be done later in regulations. And the problem with that is, well, there's a question about this later, but the problem with that is, what do you mean by PBSA? But no, I don't think there's much chance that there's going to be an exclusion of students and HMOs. The government has already put in a ground for possession, being ground 4A for student property. That is their solution to the student problem. I do not expect them to create a blanket exclusion that takes student groups outside the remit of this, and the NUS would oppose that staunchly if they tried.
Yeah. Okay. So what we've got now is quite a sequence of questions about licenses, which is quite predictable given the last conversation that we had when this was raised. So I would like to understand how we can start using licenses for student lets over tenancies. Where's Boswell?
Yeah, I mean, as I said last time, you shouldn't just start using licenses based on what some lunatic has said to you on a webinar. So the first thing you need to do is take some proper legal advice that relates to your actual situation, because this is a generic comment. But in principle, if you are offering service or attendance in a property, and that service or attendance cannot be offered while the tenant at the same time has exclusive possession of the space, then it is legal to have the property on a license. So what you would need to be doing is deciding what mechanism you're intending to use. It's not the only way to end up with a license, but it's the best way in practice. So the first question is, what do you intend to do to make it a license? Is that your best option? There are a couple of other things you could try. And then you need to do costings and make sure it actually works for you. I mean, it's just not going to work for every landlord. Then what you need to do is get someone to draft you or produce for you an appropriate license agreement that you can use.
Yeah, I mean, you can't just cross out the word tenancy at the top of the document and write in license, can you? It's more complicated than that, isn't it?
That has
Obviously.
been tried many times, and one of the
Yeah,
problems with doing that is the courts have generally held that some great long screed, like you would get for a tenants agreement that reserves lots of rights, is incompatible with being a license because you don't need to reserve lots of rights because the tenants don't. Well, sorry, tenancy. I've done it again. The occupiers in a license agreement have very limited rights as a matter of law, so you don't need such a long document. They can have their license terminated fairly easily.
so, I mean, in simple terms, I suppose what we're talking about is where yeah, again, I'm using the wrong word as well. The occupier no longer, it's so easy, isn't it? The occupier no longer has exclusive right over the property in the same way a tenant would. So,
Yeah.
I mean, would it be reasonable to suggest that you're almost talking like a hotel where
Yeah.
somebody's got a room and they can live in that room for as long as they pay the bill, we'll say, as it's a hotel, but the hotel can come and go, they can change the towels, they can clean the room, so on and so forth. You don't
This is
have
a
a
good
right to
example
deny
because
them. Yeah,
lots of people think there's some special law that says hotels are hotels, but there actually isn't. There's no specific piece of legislation. There's obviously legislation around hotels, but there's no specific piece of legislation that specifies the nature of your occupancy in a hotel. It is a form of license. And the reason that it's a form of license is that hotels provide attendance. That is
yeah,
why if you go to a hotel, even a relatively high-end one, it is quite difficult, even with excessive use of of do not disturb signs,
yeah,
actually keep them out of your room for more than a day. They will come in, they will, and it's a policy decision from the point of view of hotels. It is their policy to enter onto people's rooms because that is how they maintain their status.
yeah. And so I mean, clearly we're not telling people that you've got to put the word hotel over the top of the building, but essentially it's that sort of level of intrusiveness, isn't it, that we're talking about to be able
Yeah,
to
and
claim
there are a number of ways
license.
to
Yeah,
obtain that. So, for example, it is also a license if you don't allocate a room until people arrive. So you'll know if you go and stay at a hotel, you can ask for a specific room, but hotels always have in their small print, will try to honour your request, but rooms are allocated on arrival. That again is one of the things that makes hotels hotels. So
yeah,
you can operate your license that way, but it's not usually enough on its own because the trouble is you have to show that you genuinely do actually do that, and sometimes and in practice most people don't, even though they claim to. Another thing that makes a hotel is the ability to ask you to simply shift rooms. So, for example, if you're staying at a hotel and the air conditioning breaks down and you go and complain about it, their most likely solution is to simply move you to a different room and get it fixed. And they'll, if it's a nice enough hotel, they'll send up nice, helpful people who pack your stuff for you and shift it all for you. If it's a less helpful hotel, they'll tell you to shift yourself. Depends how much you paid. But
yeah,
their
of
primary
course.
solution, if your room is unsuitable beyond a certain point, is to simply shift you into another room. In principle, that is one of the things that makes it a license, and you can write that in a license agreement. But the reality is, you then have to show the courts that you actually did that, and it was a matter of policy, and it's quite difficult to do. But then the third thing that's particularly effective is providing an attendance, and the most obvious attendance is in-room cleaning, obviously.
Yeah.
Uh, and that tends to be the one that most people plump for, and the courts are fairly habituated to accepting that as a concept.
Okay, that's a bit of an example there, isn't it? So let's roll on. So because we've got quite a few of these licensed ones, but I suspect there's going to be a similar sort of response. So you mentioned in the last webinar that licenses to occupy could be where weekly cleaning is provided, and there is case law to back this up. I mean, this is exactly what we've just been talking about, isn't it? Really?
Yeah, I've kind of answered this question, but the case law is very clear that if you provide attendance that cannot be provided without undermining exclusive possession, such as walking into someone's room every week, whether they're happy about it or not. And that doesn't mean you just kick the door in, but you have in your agreement, we are coming in on a particular schedule to clean, and you must provide access and must make it available. And your cleaner comes along, bangs on the door, and says, "I'm here to clean." And if they say you can't, and say, "Right, well, I'm coming back in an hour to clean," and you're quite forceful about it, as you would be in a hotel, then that is a regular attendance, and clearly, because you're ignoring any demand or suggestion that you don't have a right to do it, or that the occupier has exclusive possession, they are not a tenant. Exclusive possession is the thing that makes a tenancy a tenancy. It's critical to the formation of a tenancy, the right to exclude all others.
Yeah.
As soon as you take that away, then you are undermining the existence of the tenancy at all.
Yeah, I mean, I can think of which I won't name, but I can think of a fairly large PBSA operator that has weekly cleaning, and that's specifically one of the reasons that they do it for. So, it enables them to be able to write licenses instead.
Yeah, and
Okay.
quite a lot of university accommodation traditionally was operated on a license model because it's cleaned regularly, and some of it still is.
Yeah.
It's
Yeah.
dropped away because increasingly universities, the economics don't work so well from the point of view of the university. Students tend to want cheaper accommodation, or they don't want someone coming in, so they've moved to other models. But in principle, you can do it, and quite a lot of people still do.
Yeah.
If you would stay at Oxford College, those are all on licenses, for
Yeah.
example, and they still continue to provide full cleaning and in-room attendance.
Yes, I mean, and there's some that still, that, as you say, still do that. Well, certainly, our university used to do that in the past. I don't think it does anymore. It's long since stopped doing the regular cleaning in that sense in the room.
Well, it's
Anyway.
partly because a lot of universities refigured their accommodation into sort of mini flat type styles, where you had groups of homogeneous groups of say 8 people in a sort of quasi flat arrangement, and you may then clean some of the communal areas, but you tend not to go into the rooms.
Yeah, and that's a key thing, isn't it? Really, it's access to the room. It's not the communal areas, isn't it?
Yeah. Right. So yeah, this is a good question. What areas are licenses not covered that are exempt for? Well, licenses are exempt from if you don't have a license, then you don't have what's called a relevant tenancy, which is an assured tenancy under the Housing Act 88, which is what the Renters' Rights Bill creates. You will still be subject to HMO licensing and things like that under the Housing Act 2004. You will still be subject to the Tenant Fees Act, as you are now, so you will have to comply with deposit limitations and legal fees. You will not be covered by lots of the new things in the Renters' Rights Bill. You will not be covered by the Decent Home Standard. You will not be covered directly by Awab's law, but the government has reserved a power to itself to make regulations in respect of licenses that effectively do Awab's law by the back door. You will not be covered by tenancy deposit protection under the Housing Act 2004. You will not be covered by landlord redress schemes. You will not be covered by the PRS database. So you don't need to turn up to the register for the National Register. So a huge chunk of the stuff that the Renters' Rights Bill operates under just is not going to intersect you. You're still covered by a lot of the enforcement and investigatory powers within the bill, but a lot of the core stuff about landlord database, redress schemes, no fixed terms, all of that stuff goes away. And this is where it becomes quite interesting, because obviously there is a cost to providing in-room attendance like cleaning, but then there's also a cost to joining a redress scheme and the PRS database. And depending on how the fee structure stacks up, it may be economically better to offer cleaning, even if you're not able to defray the full cleaning cost against tenant rent. Tenant rent, occupier license fees. It's so easy to do. Even if you're not able to defray the full cost of the cleaning against occupier license fees, it may still be worth it because you're with removing other cost from your obligations by taking out the cost of joining the redress scheme and all of that stuff.
Yeah, yeah, that's pretty significant stuff as well. Some of the things that you're exempt from there that you've mentioned, isn't it? Obviously, as well.
It does depend when and where but it does depend exactly how the fee structure stacks up, and no one knows what that will be yet, and that's a core cost.
Sure. Okay. Do we have another one? Yes. So this is at a university. This is actually at Kellogg College. If we operate a license, I'm quite understand this. If we operate a license, are we still required to follow the bill's advertising guidelines? I.e., currently the accommodation is marketed.
No. Overbidding. This is about overbidding requirements.
Right. Okay.
Overbidding. The overbidding rules don't apply if your intention is not to let the property on a relevant tenancy. So again, something else that simply doesn't apply to license agreements. So
Right.
yeah, Kellogg College are able to operate licenses. They they can advertise it as current year with TBC. And what I should say is that material information under the Consumer Protection from Unfair Trading Regulations would still apply to you, and it is the view of the NTS ELAT that you should advertise with a clear fixed price, but not everyone agrees that the NTS ELAT's interpretation of material information is correct. So,
Okay.
so that there is that side issue you may want to consider.
Okay, hope that helps you then, Joe. Next one, how will the bill affect students? Would we have to change anything in our licence for the halls of residence? Now, again, this is somebody who's Sue Mannion, who's calling from Imperial College. So,
if you're
presumably not.
operating a license agreement, then I doubt it will need to change at all as a result of this bill. There are things that will change, but they're mostly investigatory powers and things like that. What you should be aware of and what you may need to change is you will need to look out for what the government intends to do about imposing minimum standards in respect of licenses and how they intend to do that. And it may be that that will cause you to change your license agreement. But as things stand today, I don't anticipate you needing to make any significant changes to a license agreement.
I suspect for the big operators and the universities, this isn't going to be much of a problem. It's going to be more problematic for a small landlord with one or two houses.
Some universities and big operators have moved granting ASTs. But I imagine, yeah, many of them will move back to models that they operated in the past.
Yeah, okay, thank you for that. If PBSA is exempt from this, how will we know what classifies as a PBSA? So it's a good question. This is, does all student exclusive accommodation qualify, Jane Goldsby?
Right, I mean, to answer the second question first, probably not. And to answer the first question is no one is sure. All the government has said in their explanatory notes is that they will pass regulations to ensure that purpose-built student accommodation is exempt. And the way they will do this is there are regulations that already exist that sit under the Housing Act 88, which basically have a laundry list of mostly universities plus some other people who are allowed to grant licenses or tenancies outside the scope of the Housing Act 88. And they're in most cases granting tenancies. They're just not ASTs, they're not Housing Act 88 tenancies. And they're the same as are used elsewhere in the market for people who are renting over £100,000 or where you're granting a tenancy to a company, all of which fall outside the scope of the Housing Act 88. But the problem with the statement of the government is that purpose-built student accommodation will be exempt is no one knows precisely what they mean by purpose-built student accommodation. And that's quite a wide spectrum. And the problem, of course, is that lots of purpose-built student accommodation isn't really purpose-built. A lot of purpose-built student accommodation is something else. So a commercial property that's been converted into student accommodation. Will that fall within the definition of purpose-built? I do not know. It doesn't fall into the plain English meaning of it, but most people would probably call it PBSA. Quite a lot of property that has ended up in PBSA, particularly in London, is actually just generic property that was built and the developer hasn't been able to sell flats or get it into some other market, and so has fitted it out as PBSA. And you can certainly find places around Canary Wharf and the Olympic Park where they're currently occupied by Unite as student accommodation, but that's not necessarily what was in the developer's mind when they were built. So the problem with the phrase PBSA is it covers quite a wide range of stuff.
Yeah.
Some of which is not really meeting the PB element of PBSA because it wasn't built from the moment of bricks being laid down or original design plan as student accommodation.
Yeah.
So,
as you say, there's a difference between office blocks that have been converted or what have you that have been converted into student accommodation and something that Unite builds, which is like a 600 bed space place that from day one it intended to be student accommodation, I guess, right?
Yeah. So I mean, if I thought I might be a PBSA operator, I would be thinking very carefully about my position. I would consider whether I was confident I would fit into most definitions of PBSA. I would consider whether I could, in fact, operate under another model like license agreements that would mean that I didn't care about the PBSA definition. And I might well be writing to appropriate civil servants or employing somebody on my behalf to write to appropriate civil servants to make some comments about what I thought should be within the PBSA exemption and why.
Yeah. Okay, so let's move on. In some
Well,
of
while we're on
your
that topic, I just noticed that there's a question. Well, in fact, this question as well. So let's go to Nicola's question because I suppose that Karen Stanley's asked a similar question.
okay,
So Nicola's saying it might be possible to register an existing to full time as PBSA. Can I also say, well, the answer to that question is I don't know. It entirely depends on what the definition of PBSA is. But I noticed that Karen's asked the Simpson question that says, if a university gives a purported license to students of a private residential of HMO 7 rooms, they appear to rent directly from landlord, so a rent-to-rent agreement, would this PBSA? Well, probably not, because it's not purpose-built.
yeah,
And I don't know if the government's intending, and this is why the government's use of the phrase PBSA is quite unhelpful. I don't know if it will cover rent-to-rent, but I should also point out that it's not just a PBSA exemption. What the government has said is it's PBSA where the member is a member of the Unipol or UUK code. And as things currently stand, both the Unipol and UUK code specifically exclude properties where the university rented it off a landlord and then rented it back out to students. So a rent-to-rent arrangement run by a
right,
university. They are unequivocally excluded from the code. So even if you might say they were PBSA, they're not within the current code. So unless the codes change, you still won't get into the PBSA definition because it's got two legs to it. But this is why it's problematic. Does PBSA also include CSA or CBSA, converted built student accommodation that was, or I would call it PCSA, purpose converted student accommodation? Is PBSA require me to have built it, or simply that I have converted it or reconstructed it for this purpose from some other use? And that's why the definition is quite hazy and unsatisfactory.
okay.
So I've answered that question, and also one of the ones that someone had asked on the side. So great.
Oh, okay, well, we'll skip that one later on then. So, what are the implications for contracts we are getting signed now for summer 2025? And this is a good one, isn't it? If a tenant has moved in under the current AST, do we need to reissue contracts once they're brought in? So, I suppose that what they're talking about is stuff where it's operational now,
So I don't
as opposed
know
to in the
for sure.
future.
I can't tell you for sure because this will have to be dealt with within the transitional arrangements, which the government will only set out in regulations later. And this is one of the annoying things about this, where I don't think they've really thought very carefully about the student sector. What I can tell you is that if you're intending to rely on ground 4A, you are obliged to tell tenants before the tenancy commences um, um, that the ground that you will intend to rely on ground 4A. The legislation has a turnover period. It has some transitional stuff in it, and one of the things it says is that within a month of it coming into effect, you must tell tenants if you intend to rely on ground 4A. So one of the key things that people will have to do if they're signing ASTs now that intend to convert is within a month of that conversion happening, they will have to give a ground 4A intent to use notice to whoever their tenants in fact are. I assume that you will need to reissue contracts because the government has specified that you will have to have contracts in a specific format, but I do not know what timescale the government will put on that, and how long you will have, and whether it will therefore actually affect tenancies that are in play now,
Right.
or whether you'll manage without, as it were.
because the extension of this question really, I suppose, is, as we know, because of the way the student market works, and it always people book up early because that's the nature of things. Most operators and most individual landlords, October, November, so now basically they'll start renting for the following year, starting in July, August, September. They're almost certainly going to get caught by the changes. So it's what would happen. So there's ones that are operating this minute, and that the law may come into play during this current academic year, for want of a better way of putting it. And there's ones for next year, isn't there? And so the ones for the next year are almost certainly going to get caught, and will presumably have to have documents reissued again. I'm not going to call it tenancies. I'm going to just say contracts reissued. Then you think that's the case?
Yeah, I think the government will require you to reissue contracts, but I don't know what the timeline will be. And depending on when everything happens, the timeline may end up being such that the existing contracts that you're signing now will have finished, and you'll be on to the next lot. So it's hard to be sure.
I mean, the problem there, particularly with regard to what rent periods are going to be and things like that, because most people will be issuing them with saying termly and things like that, won't they, I suppose? And that's not going to be allowed any further.
This is one of the couple of questions.
Yeah. Okay. So we'll roll on then. So that's the wrong way. That's the right way. What do agents plan? I mean, I'm not too sure how you can answer this one. So, what do agents plan to charge landlords when tenants give notice near the start of a tenancy? Will they be reducing their setup fees? I mean, look,
it'll be on a per negotiated agent basis. My understanding is that most agents have no intention of changing their current fee structure at the moment until they see how things shake out.
Right, there you are then. I mean, clearly, if somebody does give notice 2 months, gives 2 months notice, like the week after they move in or something like that, the actual landlord's probably not going to be very happy. But I suppose that's a commercial decision for the agents of whether or not they're going to give them another one for free, so to speak, or just say, well, sorry, we're going to re-rent it again. I'm guessing, yeah.
Currently, most agents' terms say they will charge you again, but in practice, if you stay with them, they will tend to waive some of the fee.
Yeah.
But that will be up to the agents, and my understanding is that most of them won't make any immediate changes.
Right. Okay. So we'll have to see how that plays out. What is the outcome for a landlord who uses ground 1A to evict, but then can't sell, or they are trapped? Are they trapped and unable to get an income from the property and only left with costs? So this is somebody who's trying to sell a property, isn't it, I suppose?
So as things currently stand, you're in a lockout period from the moment you serve a ground 1A notice until 12 months after the date the tenant is supposed to vacate. If the tenant leaves and you can't sell, the government's attitude to some extent is, well, you've probably priced it too high. And the problem with it is there's an anti-avoidance position in here, which is to stop you saying, oh, well, I'm intending to sell, chucking it on the market with a totally unrealistic price and going, oh, well, sorry, couldn't sell, and then pulling it back into the rental sector. So my answer to you is that as things currently stand, you are stuck, unable to get income for the property. So if you are intending to evict a tenant with intention to sell, I suggest you make very, very sure that you do intend to sell, that you have got some decent valuations in place already from agents, and that those valuations are matching the kind of price that you need to get from the property.
But even so, if you can't sell it, even if it is matching what you expect to get for the property, you've still got this 12-month lockout period, haven't you, essentially? So if it's just, well, we thought it'd be worth 300,000, but we can't get it, it's tough. You are locked out.
But there are lots of things people can do to help with that. I mean, you could get a conveyancing solicitor ready to go early and get them to look at any potential blockages or problems within your in your paperwork to make sure that it's unlikely, the conveyancing is unlikely to fall through. You can make sure it's marketed with all potential problems up front, and you can price it in a way that is keen. The trouble is that lots of people price their properties relatively slightly higher than they're actually worth, and get people to bid up to it. The reality is that properties are worth what people are prepared to pay for them, and if you price your property and no one's prepared to pay that much money, then it's probably overpriced.
Yeah, but as you say, the real thing behind this is it's a sort of an anti-avoidance clause, isn't it, to try and stop people from saying, oh yeah, we're selling it, and then they don't sell it, and then just throw the tenants out and getting somebody else in, I guess. So Okay, so moving on. Once the legislation is live, as per current wording, the bill can rent in advance be collected for new lets or pre-existing tenancies that were contractually obliged to pay rent in advance. So this
Well,
was
the
what we were
position
just
on
talking
rent in
about, wasn't it?
advance is incredibly unclear, um, because because the government seems to think that you can only have 1 month rental periods, but you can ask for multiple ones. Um, in any event, there's an exception. And if your rental advance was collected before the bill came into effect, you can have it. That's absolutely fine. What is less certain is any rental and advance payments that are due after the bill comes into force. And this is where it gets really time sensitive for student landlords, because if the bill comes into effect in the summer, early summer, which is what the government's sort of hoping for, then that's probably going to be before most student tenancies actually begin and before the first rent and advance payment is due, in which case you may not be able to have it. If, however, the government brings it into effect in, say, October time, which is the sort of end of their window of desire, then most of the tenancies will have started and you will have got your first rent and advance payment for the first term or the first 6 months or whatever it might be. And you can have that, but then any future ones aren't likely to work out. So the answer to that question is it kind of depends what the final position is on rent in advance. The government is very unclear about it at the moment. It's one of the areas where they say they might change the bill to make rent in advance completely impossible. At the moment, they seem to think it's sort of possible, but I'm not convinced the bill allows it. Um, and but if depending on exact timelines, you may be able to get away with it because you'll have taken the payment before the bill takes effect.
Yeah. Okay. Okay, so we've got the last few now. So contractual tenancies will be outside of the legislation, I believe. Is there any reason why we could not sign up parents, guardians as the tenants with the students as permitted occupiers? I don't really understand that myself.
Yeah, you
Hopefully
can do
you do.
that. So yeah, you can have the parents as the tenants, but because they won't be occupying the property themselves, it will be outside the remit of the Housing Act 88. Um, so yes, it is a perfectly acceptable mechanism and a means of bypassing the legislation. You are quite right. Um, I suppose the challenge is you're going to have to persuade the parents to sign that agreement, but if that's the only one that's on the table, then yeah, they may well do so.
Okay, there you go. That's interesting. The student ground for possession, is this workable in London? Will it put landlords off from letting students? What about students on study abroad exchange or 15-month MA courses? And this is from a university, Sabine
Yeah.
Ernst from the University of the Arts.
Do I think it's workable? Probably not.
No.
But in a sense, it's no more or less workable than the situation now in a way, because if tenants don't leave now, you have to serve a notice, probably a Section 21 notice, and then go to court, which will take you like 7 months. In which case you've lost the next letting anyway.
Yeah.
Um, I expect most landlords will serve ground 4A notices, and I expect most students will in fact leave, and therefore it probably won't matter all that much. Um, for ones where it doesn't work out, then I think there's going to be quite a serious problem, but no more or less technically than there is now. The difficulty is that at the moment you tend to have fixed term tenancies, so people tend to leave. But
Yeah.
yeah, and then the other areas, yeah, unusual courses that fall outside the remit of the legislation, I can see that being a serious problem. I agree. I don't have an answer for that. And neither does the government.
No. How will guarantor agreements work as normally set for the duration of the tenancy? Marion
They will
Money.
work as they are now. There's a widespread misperception that it's an unfair term to have a never-ending guarantor agreement that runs as long as the occupancy of the property. That's never been definitively proven. And I see no reason why you can't have a guarantor agreement that persists as long as the tenant's in occupation. Obviously, it would be up to the courts to make a ruling if they consider that was an unfair term.
Yeah. Okay. Very helpful. If the payment frequency is set to monthly payments on an agreement, but a tenant wishes to make rent payments up front, say for a few months to 6 months, are we able to take this? It sounds like I'm trying to get around it, doesn't it, essentially?
Probably, but it's pretty risky. You'd need to show it was definitely the tenant who asked for it, and you hadn't in any way encouraged it. But there doesn't appear to be any penalty in and of itself for taking a rent in advance payment. It's just that you can't enforce it. So
Right.
yeah, you probably can.
Okay. Okay. Yeah. Right. Okay. So that's the end of the sort of pre-posed questions, if you like. Let me just see if I can stop this share.
There's some in the chat and there's some in the
We
Q&A.
we do, don't we? So I'm looking at the well, we've got a bit of a mix then. So student tenancies under the chat. With student tenancies, is there anything within the legislation that would prevent us when signing up tenants and letting them know we intend to use ground floor A? Presumably
Yes,
we've got
because
to.
if you do or say anything that looks like you're trying to set out a fixed term tenancy, that is an offence. And I think that structure that says we're intending to use ground floor A on this date starts to look a bit like you're trying to get to a fixed term tenancy, which is an offence. So no.
Okay. What is the expected date of the implementation of the Renters' Rights Bill? Well, we don't really know that, do we? I suppose.
No, but the government has made clear it's aiming for somewhere between the summer and October.
I mean, this is definitely one for you. Do you have experience, or can you recommend anyone who has successful experience in the practical implementation of a licensing agreement? Would probably speak to you, wouldn't it? I would say.
Yeah, I've done it. I have clients who've done it, and I've done it with them. Yeah, it's perfectly possible.
Yeah, of course. Karen Stanley, if you
And indeed, I noticed there are lots of people on this webinar who are using them. So
yeah,
there are lots of people here who've done it.
yeah, okay. If a university gives a purported
So
license,
that one's okay.
that was the one that you said about Karen. Yes. If you signed an AST now for summer 25, could you then cancel the agreement and issue a license instead prior to an RRB coming in?
I don't know how you would cancel the agreement. You can't just cancel an agreement because you've got no right to do so.
Yeah. Okay. So yeah, you realistically need to do it now, don't you?
Agents often purport to cancel agreements, but if you signed it and it's not signed, it's executed, it's not subject to contract, then no, you can't cancel it because you've got no right to cancel it.
What does a common law tenancy look like? Can it have the same structure as an AST?
Yeah, it will look very similar to an AST. But there are things that you wouldn't put in a common law tenancy that have to be in an AST, and there are things that you probably wouldn't bother with in an AST that need to be in a common law tenancy. They're not dissimilar.
Yeah, I mean, I think again, it's worth reiterating that people that want to do these sort of things, you really do need to take very specific legal advice about this. This isn't something you should be just trying to do yourself, is it really? I don't think. Can you sign students up on a monthly direct debit to ease administration so they pay their share individually, but still have a joint tenancy agreement? I mean, I don't see why not. I mean, we do that. All of the tenancies that. Certainly all the tenancies we run for our HMO, I'm just speaking my personal experience there, certainly all the tenancies we run through HMO, everything is done by direct debit, and it's brilliant and it's cheap. We don't take credit cards. I would never go back to it, and we've never had one direct debit that's been recalled or anything like that. So that's my own personal experience. I can give some support for that. Does David still think that the wording surrounding pets in lets is more to do with existing tenancies rather than new lets? I.e.,
yes, I do still think that you can still advertise a property as no pets, but I will caveat that with the discrimination provisions allow the Secretary of State to add more types of protected category by regulations, and I can tell you that the pet charities are pushing very hard for pets to be added to the list of unlawful discrimination.
Okay, we've just got a few.
Now, whether they'll succeed with that is another matter.
Right. Okay, we've just got a few left over in the Q&A section now, and this is one from my old friend Julian Sparrow. Julian, can PBSA operators offer upfront payments alongside monthly and termly options within the new bill?
Well, not really, because that sounds a bit like you trying to. I mean, it depends if rent in advance is allowed, but it's a bit risky. I think I'd be a bit concerned about doing that.
Maybe type that again if you like, Julian, and see if we can answer that again if you want to clarify what you mean. Anonymous attendee, at a recent NRLA briefing on the renters' rights, landlords renting to students were advised to use subject to contract arrangements if they are renting to students now. Do you think this is appropriate?
Quite a lot of student landlords do use subject to contract, but the problem with subject to contract is if it cuts both ways. If you use subject to contract, then the students are equally entitled to withdraw from the agreement. So the reason that most student landlords don't use it is to prevent students withdrawing from agreement.
For PBSA operators who have either converted buildings or buildings that have mandatory HMO licenses, do we think that these specific buildings could not be included in the PBSA exemption? And we've spoke about that obviously earlier on, haven't we?
I don't really have an answer for you. It entirely depends how the government chooses to define PBSA, but it's certainly I would avoid pinning my hopes on it if it was really important to you.
Yeah, okay. And Jackie Abbott says, does the regular attendance for licensing have to be a cleaner, or could it just be weekly property inspection and or fire alarm testing? You've got to get in the room there, haven't you?
It doesn't be anything, but in particular, but the courts are very alert to sham attendances that attempt to look like a service which actually aren't. This sounds to me like a description of a sham attendance.
Sham, yeah. Yeah.
So I suppose in principle, yes, it could be, but I don't fancy your chances of enforcing that one in court.
Yeah, so to draw the analogy again, I mean, you go to the hotel, you almost expect that they're going to come in and change your towels, clean the room, that sort of thing. You're not really expecting them to wander in and say, we've got a fire alarm test and can we just have a look around your room? And it is, yeah, so it's going to be, you're going to see through that, aren't you, I suppose, realistically, or the court would, so should we say. If you currently let a shared student house to groups of friends without locks on internal bedroom doors, if you move to individual license agreements, would you be expected to have locks fitted to individual bedroom doors?
It's not a legal requirement as such, but I expect you to find that the occupiers would be unhappy about it, and I expect you to find the local authority under the Housing Health and Safety rating system might ask you to fit them under the security hazard.
What, to fit the locks or to remove the locks, you mean?
Fit locks.
Right.
As long as they're safe.
Okay.
So they have to have the thumb turn locks.
Okay. And yeah, and Julian said that those questions have been answered. So I think with that,
Do you have any other questions? Type real fast.
Yes, type quickly would be our advice. Yeah, type quickly. So, I mean, other than that, I will just share back the screen so you can you know how to get in contact with us if you wish. Hopefully, you can see that again now. Yeah. So, okay. So, contact me. So, obviously, the best one to contact will be David. So, anything to do with
contact Irving.
Contact me. Okay, so well, there's our two contacts together anyway. So we hope you found this useful. I think we'll probably be doing another one towards the end of the bill when it's just about to become law, which I think that will probably be useful. If David's going to be available for that, that will be useful because then we'll actually have something in place. Because obviously there is an element, you know, no matter what we do, that this is what we expect is going to happen, but you don't know until it actually passes through the Commons and so on and so forth, comes out the other side. Other than that, I'll say goodbye. Thank you very much for joining us, and yes, I hope to speak to you again soon. Take care. Thank you very much.